Thank
It'll
you.
be on, and then turn it off when you're not speaking. That's on.
Okay.
And
Good morning, everyone. The Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. I welcome each and every one of you, panelists and visitors, to today's hearing on the history and enforcement of the Voting Rights Act of 1965. I will now recognize myself for an opening statement. The right to vote is the most fundamental right of citizenship in our democracy. Everything rests upon the voter and the constituent. Yet for most of our nation's history, too many of our citizens, and particularly African Americans, were denied this most basic right, especially in my home district, the Deep South. In large measure, it took an historic march, and before that, an attempted march thwarted by the Alabama State Troopers, led by our own John Lewis, later joined by Dr. Martin Luther King from Selma to Montgomery, to bring the nation's attention to the horrific conditions faced in Alabama and throughout the South in denying people the right to vote, and even to protest and march. This protest really led to our Congress passing the Voting Rights Act. On August 6, 1965, our nation took that momentous step towards correcting the injustice when President Johnson signed into law the Voting Rights Act. John Lewis was there to witness that historic occasion. 100 years after the Civil War, 100 years after the Civil War, it took America to pass a Voting Rights Act to see to it that African Americans were not discriminated in. How many coins could be put in a bottle of water? Unless you could tell exactly how many coins might have been in a bottle of water, you couldn't vote in Alabama, Mississippi, other states in the South for 100 years. It's because of the recent developments that we've seen in our country, with our Supreme Court having ruled the Voting Rights Act unconstitutional and the failure to be able to pass an act in the most recent Congresses to renew it, that this subcommittee will dedicate itself, this Congress, to, among other things, restoring those protections by reinvigorating enforcement of the Voting Rights Act, including through the revitalization of its most important enforcement mechanism, Section 5 preclearance provisions. It's astonishing to me, as someone who witnessed as a young person the signing of the Voting Rights Act and the historic significance that that had in our country, the Civil Rights Act of '64 and the Voting Rights Act of '65, that here we are nearly 50 years later, over 50 years later, and we're dealing with it still. This hearing is the first in a series of hearings of the Voting Rights Act before this subcommittee. Our focus today is on the history and enforcement of the Act, for we must understand how we arrived at this point in history so we can discern our best path forward. Before the Voting Rights Act, the state of voting rights in the Deep South was, as I've described, abysmal. That's probably the high point. In the mid-50s, more than 80 years after adoption of the 15th Amendment, which prohibits states from denying citizens the right to vote on account of race, color, or previous condition of servitude, and gives Congress the power to enforce this prohibition, only 1 in 4 eligible African-American voters in the South was registered. That was 80 years after the passage of that constitutional amendment. This low number was a result of decades of backlash against political participation by African Americans beginning after the Civil War, being given a booster shot by Jim Crow and the awful 1876 presidential compromise. This backlash included political violence by the Klan and others who kept black voters away from the polls with guns, whips, lynching, but intimidation at all points. After Reconstruction, short-lived, Southern states enacted numerous measures to disenfranchise African-American voters as part of what came to be known as Jim Crow. These measures included poll taxes, literacy tests, the disqualification of convicts from voting, and many other measures designed to block African Americans from voting. And I should mention also the construction of many statues venerating Confederate heroes as a symbol in many town squares and public areas to say to blacks, don't you even think about asserting your rights because we're still in charge. That's what those statues meant. As a practical matter, these tactics, combined with Congress's inaction, denied African Americans the right to vote, notwithstanding the 15th Amendment's guarantee of equal voting rights. After almost a century with the substantial efforts of the Civil Rights Movement, Congress finally asserted its 15th Amendment authority, passed the Voting Rights Act with Lyndon Johnson as president. One of the key features was the Section 5 preclearance requirement. Under this requirement, certain jurisdictions, predominantly in the Deep South, that had a history of discriminatory voting measures were required to obtain the approval of the Justice Department or a 3-judge panel before any proposed changes to voting practices or procedures could take effect. The plea clearance requirement was crucial to vigorous and effective enforcement of the Act's guarantee of equal voting rights. It prevented widespread harm to minority voters and avoided expensive and cumbersome litigation by rightly settling as the default outcome the prevention of potentially discriminatory voting practices from going into effect. The pre-clearance requirement instead appropriately placed the burden of proof on the covered jurisdictions to show that changes to those voting practices would not be racially discriminatory. Those states that had pre-clearance requirements were predominantly in the Old South, and those states that had white and colored drinking fountains, days for quote-unquote coloreds to go to public libraries and zoos and all the other activities that were so opprobrious that were prevalent during that era. With this robust pre-clearance requirement, the Act had a dramatically positive effect on black voter registration in the South, which increased to 62% just 3 years after the Act became law. 6 years ago, however, in Shelby County versus Holder, the Supreme Court effectively gutted the Act's Section 5 pre-clearance requirement by striking down the coverage formula in Section 4 that determined which jurisdictions would be subject to pre-clearance. The court's majority claimed that there was no evidence to support Congress's finding of continuing discrimination in voting in these states, notwithstanding the thousands of pages of recorded evidence compiled by this subcommittee in 2006 demonstrating the continuing need for this coverage formula. And despite Congress voting in overwhelmingly bipartisan basis to reauthorize these provisions, it was like 390 to 30 or something like that, because it was American as apple pie. And it's still American as apple pie. Tellingly, in response to the court's decision, states that have been subject to the Act's pre-clearance requirement wasted no time in pursuing voting restrictions that once again undermined minority voting rights. The measures included strict voter identification requirements, restriction or elimination of early voting or same-day registration, and bans on ex-offenders from voting, all of which make it disproportionately harder for racial and ethnic minorities to vote. In short, this was the Jim Crow era, Part 2. In the absence of the pre-clearance requirement, it would be extremely difficult at best to challenge all of these new voting restrictions under what is left of the Voting Rights Act. As many of our witnesses will explain today, the remaining enforcement-related provisions of the Act that are still in effect, while valuable, are much more limited in their impact and much more difficult and costly to pursue. And it means they go into effect, and people are affected by that election until some court declares them unconstitutional later on. Moreover, in contrast to Section 5 pre-clearance, some of the Voting Rights Amendment's remaining provisions allowed only for after-the-fact relief, meaning, as I said, that minority voters would first have to be harmed before any relief could be provided. And then you've got people in office that would possibly pass acts harmful to that minority population. The results of all these factors will be that many practices and restrictions that undermine equal voting rights will simply go unchallenged. The Supreme Court was wrong, in my opinion, to undermine the Voting Rights Act. Mr. Sensenbrenner and others had voluminous evidence of the reason why the states were in the pre-clearance category. Congress must now respond. It's imperative that Congress restore the Voting Rights Act pre-clearance requirements so as to stay true to the Act's purpose of ensuring equal voting rights for all. It would be a crime if this Congress did not pass another Voting Rights Act, not only because it is really as American as apple pie, but because it is going back and providing a remedy for what was 100 years of intolerance, discrimination, and Jim Crow segregation in most of these pre-clearance states. We need to correct that, and we need to do it while John Lewis is still with us as the United States Congressman, and he can be there when this is signed into law once again. It's not enough to go to Selma with John Lewis. You need to vote with John Lewis, and you need to respect his opinion, his work, his life's work, and pass the Voting Rights Act. I thank our witnesses for being here, and I look forward to their testimony. And I now take great pleasure in recognizing the ranking member of our subcommittee, the gentleman from Louisiana, Mr. Mike Johnson, for his opening statement.
Thank you, Mr. Chairman, and thank you to witnesses for your time and your expertise today. It's very helpful to us. I and my colleagues look forward to these hearings on protecting the fundamental right to vote in America because we believe this is an honor and a critical duty of the Congress. In 2013, as you know, the Supreme Court struck down just one part of the Voting Rights Act in Shelby County v. Holder by outlining the constitutional weaknesses in Section 4 of the VRA. And I wanted to read just a portion of that opinion into the record as we start here because I think it's so relevant to what we're doing today. I start by quoting this. The framers of the Constitution intended the states to keep for themselves, as provided in the 10th Amendment, the power to regulate elections. Not only do states retain sovereignty under the Constitution, there's also a fundamental principle of equal sovereignty among the states. Indeed, the constitutional equality of the states is essential to the harmonious operation of the scheme upon which this republic was organized. Section 4 of the Voting Rights Act sharply departs from these basic principles. It suspends all changes to state election law, however innocuous, until they've been pre-cleared by federal authorities in Washington, D.C. In 1966, we found these departures from the basic features of our system of government justified. At the time, the coverage formula, the means of linking the exercise of the unprecedented authority with the problem that warranted it, made sense. Nearly 50 years later, however, things have changed dramatically. In the covered jurisdictions, voter turnout and registration rates now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. The tests and devices that blocked access to the ballot have been forbidden nationwide for more than 40 years. The court continued. The 15th Amendment commands that the right to vote shall not be denied or abridged on account of race, and it gives Congress the power to enforce that command. The amendment is not designed to punish for the past. Its purpose is to ensure a better future. To serve that purpose, Congress, if it is to divide the states, must identify those jurisdictions to be singled out on a basis that makes sense in light of current conditions. It cannot simply rely on the past. The court continued. Regardless of how to look at the record, however, no one can fairly say that it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that Congress faced in 1965 and that clearly distinguished the covered jurisdictions from the rest of the nation at the time. Our country's changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions, unquote. That was the words of the court, and of course they were right. Indeed, over the past several decades, in a reversal of prior historical trends, African Americans have been moving to and not from southern states. We're proud of that. That now tends to offer greater opportunities in the South, and people recognize it. In a recent Brookings article, William Frey outlined deteriorating working conditions that were the result of Jim Crow laws between 1910 and 1970, but the article then explains that the 2010 census revealed that from the late 1980s to 2010, new generations of African Americans, including professional and college graduates, favored economically rising southern states. This brings us to the question again of Section 4 of the VRA and its problems. The data reveals that the South has been gaining on net hundreds of thousands more African American residents over the last several decades, whereas other regions of the country are losing African American residents as they move elsewhere. The southern cities, in particular, are the most popular destinations for African American and Hispanic Americans who are moving for greater opportunities. You look at Atlanta and Augusta, Georgia, El Paso and San Antonio, Texas, Columbia, South Carolina, Richmond, Virginia, Jackson, Mississippi, Durham, North Carolina, Memphis, Tennessee, and yes, Memphis, and yes, New Orleans, Louisiana. We're all covered. We should be forever vigilant. Nolens. I love how everybody tries to be Cajun when it's used. We should be forever vigilant to oppose attempts to treat people differently on the basis of race. Of course, we all agree on that when it comes to voting or anything else. And we should take comfort when there's evidence such discriminatory treatment is increasingly becoming a thing of a past. We look forward to hearing from all our witnesses here today. And again, we thank you for the time, and I yield back.
Thank you, sir. I now recognize the chairman of the full committee, the distinguished gentleman from New York, Mr. Nadler.
Thank you, Chairman. Mr. Chairman, the Voting Rights Act is widely recognized as the crown jewel of our nation's civil rights laws. Many members, past and present, accord the act an almost sacred stature. Some, like our colleague John Lewis, shed their blood in support of its passage. Others owe their careers as legislators to its vigorous enforcement. Today's hearing will provide an important opportunity for the subcommittee to explore the history, the impact, and the need for restoration of the full vitality of the Voting Rights Act. After the VRA was enacted in 1965, its effect was almost immediate, with registration of African American voters more than doubling in the South within 4 years of enactment. Similarly, African American voters' turnout rose from only 6% to 59% in just 4 years in Mississippi, and it soared to 92% in Tennessee, 78% in Arkansas, and 73% in Texas during the same period. The net impact of VRA enforcement also resulted in the election of minority candidates of choice throughout the nation. The number of African Americans holding elected office jumped significantly, from barely 100 prior to the VRA to more than 7,200 today, with 4,800 holding elected office in the South. In national offices, the number of African Americans in Congress doubled, from 5 to 10 almost immediately after passage, and today 56 African American members serve in the House and Senate. And of course, in 2008, this country elected its first African American president. Without question, the VRA has been an unqualified success. It helped to reduce discriminatory barriers to voting and expanded electoral opportunities for people of color to federal, state, and local offices, thereby opening the political process to every American. Despite decades of evidence of the VRA's success, however, and a record spanning many thousands of pages compiled primarily in this subcommittee, documenting the continued need for the VRA, the Supreme Court, in the disastrous and shameful Shelby County versus Holder decision in 2013, substituted its own judgment for that of Congress and effectively gutted the heart of the Act, its pre-clearance provision. Before the Voting Rights Act, states and localities passed a host of voter suppression laws, secure in the knowledge that it could take many years before the Justice Department could successfully challenge them in court, if at all. As soon as one law was overturned as discriminatory in the courts, another would be enacted, essentially setting up a discriminatory game of whack-a-mole. Section 5 of the Voting Rights Act, mandating pre-clearance, broke this legal logjam by requiring states and localities with a history of discrimination against racial and ethnic minority voters to submit changes to their voting laws to the Justice Department or to a federal court for approval prior to taking effect. In Shelby County, the Supreme Court struck down the formula for determining which states and localities are subject to pre-clearance, which had the effect of striking down the pre-clearance provision itself, as there is no longer a basis for subjecting jurisdictions to its requirements. Although the court did very specifically say that Congress could enact a new formula for determining which states and localities are subject to pre-clearance, which is precisely what we should do. As John Lewis eloquently stated, this decision plunged a dagger into the heart of the civil rights movement. Unless and until Congress acts, this decision has removed the single most effective tool in our voting rights arsenal and has permitted previously covered jurisdictions to immediately enforce racially biased election laws, some of which had already been deemed to have a discriminatory impact on minority voters, without prior review. In the absence of pre-clearance, predictably, the game of whack-a-mole has returned. Within 24 hours of the Shelby County decision, both Texas Attorney General and North Carolina's General Assembly announced that they would reinstitute draconian and discriminatory voter ID laws. Both of these states' laws were later held in federal courts to be intentionally racially discriminatory, but during the years between their enactment and the court's final decision, many elections were conducted within the restrictions of those laws. In addition to Texas and North Carolina, at least 21 other states have enacted newly restrictive statewide voter laws since the Shelby County decision. The loss of Section 5 pre-clearance cuts deep into the federal protection of the right to vote. In 2006, Congress found that a majority of southern states, 2006, not 1965, in 2006, after extensive hearings in this subcommittee, Congress found that a majority of southern states were still engaged in ongoing discrimination, evidenced by some localities engaging in racially selective schemes to relocate polling places for African American voters, and some other localities annexing certain wards simply to satisfy white suburban voters who sought to circumvent the ability of African Americans to run for elective office in their respective cities. In the wake of the Shelby County decision, we have also seen the rise of voter suppression measures, burdensome proof of citizenship laws, significant scalebacks to early voting periods, restrictions on absentee ballots, and laws that make it harder to restore the voting rights of formerly incarcerated individuals are just a small sample of recent voting changes that have a disproportionate impact on minority voters. While such actions may violate other provisions of the Voting Rights Act, time and experience have proven that it takes far longer and is far more expensive to pursue after-the-fact legal remedies. And once a vote has been denied, it cannot be recast. The damage to our democracy is permanent, and the game of whack-a-mole has resumed. That is why I hope that members on both sides of the aisle and in both chambers of Congress will come together and pass legislation to restore the full vitality of the Voting Rights Act. Today's hearing will provide an important opportunity to renew our understanding of the importance of the Voting Rights Act and to set the stage for additional oversight hearings on the issues presented by the current legal regime. We must use this opportunity to promptly craft a legislative solution that enables the Justice Department to effectively enforce the rights of minority voters within the contours of the Constitution. While this is not an easy challenge, given the gravity of the issues involved and our long history of bipartisan cooperation in this endeavor, it is one that I believe our committee will and must meet with success. I yield back the balance of my time.
Thank you, Mr. Nadler. Appreciate your work in this area over the past when you were chairman of this subcommittee and as a member of Congress. It's now my pleasure to recognize the ranking member of the full committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. I do appreciate it, and I appreciate the words of not only both you and Mr. Johnson, but also the full committee chair as well. This is the first of many of these hearings, and we're looking forward to going forward. The right to vote is what makes democracy a democracy. America's federal law has protected this right from discriminatory barriers since the Civil War, and more recently through the Voting Rights Act of 1965. Americans oppose racial discrimination as incompatible with democracy, and our current laws reflect that conviction. In 2013, the Supreme Court struck down a single part of the Voting Rights Act, Section 4. That provision automatically put certain states and political subdivisions under the Act's Section 5 pre-clearance requirements. Those pre-clearance requirements prevented voting rules change covering jurisdictions from going into effect until the new rules had been reviewed and approved, either following a federal lawsuit or more often by the Department of Justice. When the Voting Rights Act was enacted, Section 4 identified the jurisdictions automatically subject to those special pre-clearance requirements by a formula. The first part of the formula provided that a state or political subdivision would be covered if maintained on November 1, 1964, a test or device restricting the opportunity to register and vote. The second piece provided that a state or political subdivision would also be covered if the director of the census determined that less than 50% of persons of a voting age were registered to vote on November 1, 1964, or less than 50% of the persons of voting age participated or voted in the presidential election of November 1964. In its Shelby County decision, the Supreme Court struck down the automatic pre-clearance provisions because the original coverage formula was, quote, based on decades-old data and eradicated practices. In 1965, the states could be divided into two groups, those with a recent history of voting tests and low voter registration and turnout, and those without those characteristics. Congress based its coverage formula on that distinction. Today, the nation is no longer divided along those lines, yet the Voting Rights Act continued to treat it as if it were. The courts further criticized Section 4's formula as relying on decades-old data relevant to decades-old problems rather than current data reflecting current needs. In Shelby County, the Supreme Court only struck down that single outdated provision of the Voting Rights Act. Significantly, the other very important provisions of the Voting Rights Act remain in place, including Sections 2 and Sections 3. Section 2 applies nationwide and prohibits voting practices or procedures that discriminate on the basis of race, color, or the ability to speak English. Like other federal civil rights laws, Section 2 is enforced through federal lawsuits, and the United States and civil rights organizations have brought cases under Section 2 to the court, and they may do so in the future. Section 3 of the Voting Rights Act also remains in place, authorizing federal courts to impose pre-clearance requirements on states and political subdivisions that have enacted voting procedures that treat people differently based on race in violation of the 14th and 15th Amendments. If the federal court finds a state or political subdivision to have treated people differently based on race, then the court has the discretion to retain supervisory jurisdiction and impose pre-clearance requirements until a future date at the court's discretion. This means that such state or political subdivision would have to submit all future voting rule changes for approval to either the court itself or to the Department of Justice before enacting those changes. Per the Code of Federal Regulations under Section 3C of the Voting Rights Act, a court in voting rights litigation can order as relief that a jurisdiction not subject to pre-clearance requirements of Section 5 pre-clear its voting changes by submitting them either to the court or to the Attorney General. Again, Section 3's procedures remain available today so people can challenge voting rules as discriminatory. In 2017, for example, U.S. District Judge Lee Rosenthal issued an opinion in requiring the Justice Department to monitor the city of Pasadena, Texas, because it had intentionally changed its city council districts to decrease Hispanic influence. The city, which the court ruled had a long history of discrimination against minorities, was required to have their future voting rules changes pre-cleared for the next 6 years, during which time the federal judge retains jurisdiction to review both before enforcement any change to the election map or plan that was in effect in Pasadena on December 1, 2013. A change to the city's election plan can be enforced without review by the judge only if it has been submitted to the U.S. Attorney General and the Justice Department has not objected within 60 days. This is the basis of this hearing, and I'm glad that we're having it, and I look forward to the witnesses and the questions that will come. And with that, I yield back.
Mr. Collins. We welcome our witnesses, our panel, and thank them for participating in today's hearing. I will now introduce the witnesses, but the way I do it, I don't introduce all the witnesses at first. I introduce the witness before this witness speaks, so it's a little different. So I will soon introduce is it Lhamon? Lhamon. And then you give your oral testimony. Your written statement will be entered into the record in its entirety. I ask you to summarize your testimony in 5 minutes. You've got a little light in front of you. Green means go. Yellow means you're in the 1 minute about to enter the penalty zone, and red is you're in the penalty zone. You got to stop. When the light turns red, get it done. Before proceeding with your testimony, I will remind each witness that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to penalty of perjury pursuant to 18 U.S.C. 1001, which could result in the imposition of a fine or imprisonment up to 7 years, 5 years or both. Our first witness is Catherine Lhamon, who is chair of the U.S. Commission on Civil Rights. President Obama appointed her to a 6-year term on the commission in December 15, 2016, and the commission unanimously confirmed the president's designation on December 28. She also has served, she serves in the cabinet of California Governor Gavin Newsom, where she has been legal affairs secretary since January 2019. Ms. Lhamon previously served as Assistant Secretary for Civil Rights at the U.S. Department of Education from June 2013 until January 2017. Prior to that, she practiced at the ACLU of Southern California and at Public Counsel. She received her JD from Yale University. She was an outstanding woman law graduate and graduated summa cum laude from Amherst. She clerked for the Honorable William A. Norris of the United States Court of Appeals for the Ninth Circuit, recipient of numerous professional honors. We're privileged to have her here, and we recognize you for 5 minutes.
Thank you, Chair Nadler, Chair Cohen, Ranking Member Johnson, Ranking Member Collins, members of the subcommittee. Thank you very much for inviting me to testify. As mentioned, I chair the United States Commission on Civil Rights, and I come before you today to speak about a report released last September titled An Assessment of Minority Voting Rights Access in the United States, which I ask to be submitted to the record alongside my testimony today. With this report, the Commission returned to a topic that was a core basis for Congress' creation of our commission, now 62 years ago, advising the U.S. Congress, the President, and the American people about voting rights and civil rights more generally, and making recommendations for improved policy. Over the years, the Commission's work has supported the basis for the 1965 Voting Rights Act, provided evidence on which the United States Supreme Court relied to uphold the constitutionality of the Voting Rights Act, and issued 20 previous reports over 62 years specifically focused on voting rights. This most recent report offers an independent, comprehensive, detailed analysis of the current status of voting discrimination in the United States and voter access in the United States, and of the efficacy of the United States Department of Justice enforcement of the Voting Rights Act since Congress' 2006 reauthorization, and in particular, since the Supreme Court's June 2013 decision in Shelby County versus Holder. Drawing from Commission research and investigations and memoranda from 13 of the Commission's state advisory committees who analyzed voting discrimination in Alabama, Alaska, Arizona, California, Illinois, Indiana, Kansas, Louisiana, Maine, New Hampshire, Ohio, Rhode Island, and Texas. This report documents current conditions evidencing ongoing discrimination in voting. On every measure the Commission evaluated, which includes litigation success, data regarding discrimination incidents, investigations from state advisory committees, and commission testimony from 23 bipartisan voting rights experts and advocates, as well as in-person and written public comment. The information the commission received underscores that discrimination in voting persists now. Our report found that at least 23 states have enacted newly restrictive statewide voter laws since the Shelby County decision in 2013. These statewide voter laws range from strict voter identification laws, voter registration barriers, such as requiring documentary proof of citizenship, allowing challenges of voters on the rolls, and unfairly purging voters from rolls, cuts to early voting, to moving or eliminating polling places. The conclusions the report draws are bleak, leading to unanimously voted commission findings, including that during the time period we studied, race discrimination in voting has been pernicious and endures today. Likewise, voter access issues and discrimination continue today for voters with disabilities and limited English proficient voters. The right to vote, which is a bedrock of American democracy, has proven fragile and to need robust statutory protection in addition to constitutional protection. Following the Supreme Court's decision in Shelby County, in the absence of preclearance protections of Section 5 of the Voting Rights Act, voters in jurisdictions with long histories of voting discrimination faced discriminatory voting measures that could not be stopped prior to elections because of the cost, complexity, and time limitations of the remaining statutory tools. The Shelby County decision had the practical effect of signaling a loss of federal supervision in voting rights enforcement to states and to local jurisdictions. The number of successful lawsuits brought pursuant to the Voting Rights Act, to the nationwide prohibition in the Voting Rights Act of any voting practices and procedures that discriminate on the basis of race or membership in a language minority group has quadrupled in the 5 years following Shelby County as compared to the 5 years that preceded. These federal court findings of discrimination followed extensive evidence and rigorous litigation. As a result, the Commission recommends that Congress should amend the Voting Rights Act to restore or expand protections against voting discrimination that are more streamlined and efficient than the provisions of the Act. The new coverage provisions should take account of the reality that voting discrimination tends to recur in certain parts of the country, and the voting discrimination may arise in jurisdictions that do not have extensive histories of discrimination. I see that my time has expired. I will reserve and look forward to questions.
Thank you. Thanks so much. Mr. Thomas Science is the President and General Counsel of the Mexican American Legal Defense and Educational Fund, position he's held since 2009. Prior to that, he served as counsel for the mayor of Los Angeles. Prior to that, he was a litigator for 12 years with his group acronym MALDEF, which is Mexican American Legal Defense Education Fund. He was lead counsel, successful challenge to California's anti-immigrant Proposition 187, and he led numerous civil rights cases in the area of immigrants' rights, education, employment, and voting rights. Served as lead counsel in 2001 challenge to the congressional redistricting in California. He served as MALDEF's lead counsel in 2 court challenges to Proposition 227, a California English-only education initiative, lead drafter of an amicus brief on behalf of Latino organizations supporting affirmative action in the Supreme Court case of Grutter versus Bollinger. He received his JD also from Yale and his undergraduate degree summa cum laude from Yale. But he was not named the top woman graduate at Yale. He later served as law clerk for the Honorable Harry L. Hupp of the United States District Court for the Central District of California, and to the Honorable Stephen Reinhardt of the United States Court of Appeals for the Ninth Circuit. For 8 years, he taught civil rights litigation as an adjunct lecturer at the University of Southern California Law School and has been widely published. You're now recognized, sir. 5 minutes.
Thank you. Good morning, Honorable Chair and members of the subcommittee. I am Thomas Science, President and General Counsel of MALDEF. MALDEF is currently commemorating 50 years of promoting the civil rights of all Latinos living in the United States. And through that half-century of service, we have focused on specific issues. Most prominent among these is voting rights. We have focused from the beginning on securing the right to vote for members of the Latino community, initially through the courts under the Constitution, and then after working in Congress to have the 1975 amendments of the Voting Rights Act extend its protections to the Latino community. We have litigated in court under Section 2, the central protection against minority vote dilution, under Section 203, governing the provision of bilingual ballot materials, and under Section 5, prior to its ignominious dismantling by the Shelby County decision. Specifically, we litigated under Section 5 because, most importantly, the entire state of Arizona, the entire state of Texas, and significant counties in California were covered jurisdictions prior to the Supreme Court decision. We have challenged at-large systems. We have challenged discriminatory redistricting. We have challenged new barriers to voter registration. We have challenged new barriers to ballot access. And we have challenged the failure to provide bilingual ballot materials where they are required. The Voting Rights Act has been an important tool to secure the civil rights of the Latino community for at least two reasons in two circumstances. First, in the Southwest and isolated communities around the country, there is a long, long history of a significant Latino population and significant representation in the voter pool, and those communities have seen for decades significant histories of efforts to prevent the full participation of Latino voters in elections. There have been practices followed in those communities that very much parallel the circumstances in the Deep South described by the chair for the African American community. But separate, there are new communities across the country in virtually every region of the country where there are now prominent Latino populations. And as those populations reach a position of power, political power, there are often efforts by those in charge to prevent them from taking significant political power. In attempting to prevent newly growing Latino communities from achieving voting power, these communities often adopt the same strategies and practices that we've seen over the decades in the Deep South and in the Southwest, particularly faced by the Latino community. It is safe to say that MALDEF, since the 1975 amendments, applied the protections of the Voting Rights Act to the Latino community. MALDEF has been the most prolific enforcer of Latino voting rights in the country. However, that term prolific largely overstates what we have been able to do, and that is simply because of the burden and expense of enforcing the Voting Rights Act. Section 2 and its operative test of assessing the totality of the circumstances means that it is difficult for MALDEF or any of the many other organizations that enforce through private actions the Voting Rights Act to fully pursue what needs to be pursued to preserve the right to vote for minority communities. I will provide one example. After the last redistricting in California, MALDEF identified 9 counties throughout the state of California where the Board of Supervisors should have drawn an additional Latino majority supervisorial district, warranted by the growth of the Latino community, its concentration, therefore the ability to draw a district, and evident patterns of racially polarized votings. All 9 of those counties should have drawn different redistricting maps than they drew. All of them were subject to a potential Section 2 challenge. Recognizing, however, that the totality of the circumstances test meant that we would be unable to challenge all 9 jurisdictions, we sought to change state law in California, unsuccessfully, to streamline the ability to challenge those discriminatory redistrictings, and we were left with challenging only 1 of the 9 counties. Successfully, Kern County was ordered last year to change its redistricting maps and to create a second Latino majority district. But that means essentially that 8 counties in California this decade gambled, understood they might be violating Section 2, but gambled they would not be targeted because of the expense of Section 2 litigation, and so far they have basically succeeded in that gamble. That's a result of the loss of the preclearance mechanism through the Shelby County decision. Preclearance is not only a most effective civil rights device, it is efficient and effective. It is in essence one of the first alternative dispute resolution mechanisms in federal law that saves literally millions of dollars primarily for the defendant jurisdictions that would otherwise have to pay the costs their own and those of their opponents. MALDEF is proud to have been the litigator in the Pasadena, Texas case mentioned by Mr. Collins, the only contested order, judicial order, requiring a jurisdiction to be subject to preclearance. However, that came after an arduous and expensive trial, including the gathering of evidence of experts and non-experts alike over many, many months. The circumstances of that case indicate what we are unable to challenge as effectively. In Pasadena, Texas, the mayor, after the Shelby County decision, Citing that decision, recognizing that the change would not be subject to pre-clearance, changed or sought to change and successfully obtained a change in the composition of the City Council from 8 districted members to 6 districted members and 2 at large. The purpose of that change was to stem the growth in the power of the Latino vote. That is what the judge decided and subjected that small jurisdiction to pre-clearance. It is the only jurisdiction thus far subjected to a contested order of pre-clearance. That is an indication of what we face without the strong measure and effective and efficient measure of pre-clearance. Thank you.
Thank you, sir. Our next witness is Mr. Peyton McCrary. He's a professional lecturer in law at professorial lecturer in law at George Washington University here in Washington. From 1990 until 2016, he was a historian in the voting section of the Civil Rights Division of the United States Department of Justice. From 68 to 89, he taught history at the University of South Alabama, the University of Minnesota, and not Yale and not Harvard, but at the Harvard of the South, Vanderbilt University. Before joining the government in 1990, he testified as an expert witness in 14 voting rights cases, beginning in 1981 with Bolden versus City of Mobile on remand from the Supreme Court. In 98-99, he took leave from the government to serve as the Eugene Lang Visiting Professor at Swarthmore, where he taught courses in voting rights law and civil rights policy in the Department of Political Science. In 2011, he was honored by receiving the Maceo Hubbard Award for sustained commitment to work of the Civil Rights Division. He received his PhD from Princeton, his BA and MA from the University of Virginia, and he is recognized for 5 minutes and welcomed.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Vice Chairman, distinguished members of the subcommittee, thank you for inviting me to testify before you today. It's an honor to have this opportunity to speak briefly about the history of the Voting Rights Act. When the Shelby County decision came down from the Supreme Court in 2013, the majority opinion was focused almost entirely on the coverage formula set out in Section 4, which it found unconstitutional. The only part of the voluminous record before Congress in 2005-2006 on which the majority focused was the participation rates, which were the focus of the formula as adopted in 1965. And the majority took the view that because participation rates in the covered jurisdictions were substantially approaching white voter registration and turnout levels and were not particularly different from jurisdictions that were not covered in the rest of the country, that the formula no longer met the needs of current protection of minority voting rights. The 4 dissenters had an entirely different view of the record before Congress in 2006. To the dissenters, the question before the court was whether problems with racial discrimination in voting continue to exist within the previously covered jurisdictions. And that was also the focus of the voluminous record before Congress in 2006, which some of the members of this committee will recall. Now, the elimination of preclearance review leaves minority plaintiffs with only one option: filing lawsuits under Section 2 of the Act. There's no geographic coverage formula for Section 2. Its coverage is nationwide. Yet, Section 2 litigation is time-consuming and expensive, and I can testify to that through my long years of involvement in voting rights cases under Section 2. And of course, minority voters have more limited financial resources than white. The reason why the abysmal racial disparities in voter registration at the time the Voting Rights Act was adopted have largely been eliminated is, of course, the operation of the Voting Rights Act itself, initially suspending the literacy test and other discriminatory devices, sending federal examiners down to plantation counties to register voters when recalcitrant registrars would not meet their responsibilities under the Act, sending federal observers to monitor elections where problems were anticipated based on preliminary investigations, and of course, successful court orders and successful objections to voting changes through the administrative review of the Department of Justice or by the federal courts in the District of Columbia. Thus, the fact that there is essential parity between minority and majority voters in some areas of the covered jurisdictions is due to the successful implementation of the Voting Rights Act. In 1969, the Supreme Court evaluated the coverage formula of Section 5 and how it should be applied, adding to protections against vote denial, which was the focus of the formula itself. All other voting changes. The express language of Section 5 says that any voting changes are subject to the preclearance responsibilities. In the 1970s, the primary focus of many objections, both by the Department of Justice and by Section 5 courts in the District of Columbia, was vote dilution problems. That is, the kinds of laws adopted by Southern jurisdictions after 1965, as they had before 1965, that diluted minority voting strength once African Americans began to register and vote in larger numbers in the late 1960s. Vote dilution is a major part of the record before Congress in 2005 and 2006. And the problem with the elimination of Section 5 review by the Shelby County decision is that it leaves the problem of vote dilution to be solved only through the rigorous court proceedings under Section 2 of the Voting Rights Act. Since the decision by the Supreme Court, of course, another major kind of voter discrimination has been tried under Section 2, problems of voter abridgment through the adoption of photo ID requirements, changes in early voting procedures, and other ways of abridging the right of minority voters to cast their ballots. Those take even more complicated paths in the litigation process, requiring expert testimony, using complex database methodology matching techniques to investigate statewide voter registration and driver's license databases and federal databases and other data that are extremely complicated to carry out. But in some of those cases, the plaintiffs have been successful. They have been successful most dramatically in the North Carolina case, to which there was reference earlier, where the Fourth Circuit Court of Appeals found that the requirements set out by the North Carolina law adopted just after the Voting Rights Act was changed by Shelby County had been adopted with racially discriminatory purposes. I have no advice to the Congress about how to change the coverage formula. The coverage formula is one that I'm sure the committee will be addressing in serious terms. I can only tell you how the Voting Rights Act operated over the years since its adoption in 1965. Thank you.
Thank you, Professor. We now recognize Ms. L. Paige Whitaker, Legislative Attorney in the American Law Division of the Congressional Research Service, author of a number of publicly available CRS products covering topics from campaign finance laws to congressional redistricting and the Voting Rights Act. She received her JD from Catholic University of America, Columbus School of Law, and her BA from the University of Maryland. Ms. Whitaker, thank you, and thank you for all your work with the Congressional Research Service, and you're recognized.
Thank you, Chairman Cohen, Chairman Nadler, Ranking Member Johnson. My name is Paige Whitaker, and I'm a legislative attorney with the American Law Division of the Congressional Research Service. Thank you for inviting me to testify today regarding the Voting Rights Act of 1965. CRS is available to serve all members of Congress on an objective, nonpartisan basis. With these brief remarks, as requested, I will summarize a few key points from my written testimony regarding Sections 2, 4 and 5, and 3C of the Voting Rights Act. The Voting Rights Act was first enacted in 1965 under Congress's authority to enforce the 15th Amendment. Since then, Congress has amended the Act in 1970, 75, 82, 92, and most recently in 2006. Section 2, a key provision of the law, applies nationwide. It authorizes the federal government and private citizens to challenge discriminatory voting practices or procedures, including minority vote dilution, which is the diminishing or weakening of minority voting power. Section 2 prohibits any state or political subdivision from enacting a voting law that results in the denial or abridgment of the right to vote based on race, color, or membership in a language minority. A violation is established if, based on the totality of the circumstances, a minority group has less opportunity than other members of the electorate to elect representatives of choice. Courts have most frequently applied Section 2 in the context of challenges to redistricting plans. However, in the past few years, litigants have also invoked Section 2 to challenge certain state voting and election administration laws. Next, Sections 4 and 5 worked in tandem. Section 4, known as the coverage formula, prescribed which states and political subdivisions with a history of discrimination were required to obtain preclearance before implementing a voting law. It covered any jurisdiction that used literacy tests and had low voter registration and turnout in the late 1960s and early 70s. For the 1972 date, the law covered any jurisdiction that provided election information in English only, where members of a single language minority constituted more than 5% of the voting age citizens. As originally enacted, Section 4B was scheduled to expire, but in a series of amendments, the law was reauthorized and most recently in 2006 was extended for 25 years. Then, Section 5, known as the preclearance requirement, required prior approval or preclearance of a proposed change to any voting law and applied to those states and political subdivisions covered under Section 4B. In order to be granted preclearance, the covered jurisdiction had the burden of proving that the proposed voting change neither had the purpose nor would have the effect of denying or abridging the right to vote or diminishing the ability to elect preferred candidates of choice on account of race, color, or membership in a language minority. In 2013, in the case of Shelby County versus Holder, the Supreme Court invalidated the coverage formula in Section 4B, thereby rendering the preclearance requirement in Section 5 inoperable. In Shelby County, the court held that applying the coverage formula to certain states and jurisdictions departed from the fundamental principle of equal sovereignty among the states that was not justified in light of current conditions. The court ruled that in order for Congress to divide the country so as only to subject only certain states to preclearance, it must do so by showing that the statute's disparate geographic coverage is sufficiently related to the problem that it targets, based on current conditions. As a result of the court's decision, 9 states and jurisdictions within 6 additional states were previously covered under the formula are no longer subject to the Voting Rights Act's preclearance requirement. And then finally, Section 3C, which is known as the bail-in provision of the VRA, provides that if a court determines that violations of the 14th or 15th Amendment to the U.S. Constitution, which justify equitable relief, have occurred in a state or political subdivision, the court shall retain jurisdiction for a period of time that it deems appropriate. During that period, the state or political subdivision cannot make an electoral change until the court determines, or the Department of Justice, that the change neither has the purpose nor will it have the effect of denying or abridging the right to vote on race, color, or membership in a language minority. This concludes my brief remarks. Thank you for the opportunity to testify today, and I would be pleased to answer any questions.
Thank you for your testimony. Before we proceed to our questions, I want to recognize the Shelby County of Tennessee, not Alabama, as in Holder, Tennessee chapter of Delta Sigma Theta sorority. And Ms. Johnny Turner and your crowd, welcome. I'm honored that you're here today. And if you'd stand and be recognized. Thank you for your attendance. And for all your good work that you do in Memphis, Shelby County. Firstly, Ms. Lhamon, you mentioned there were 23 jurisdictions that had passed statewide laws that just diluted the vote since the Shelby decision. What do those 23 states have in common, if anything? Were they particularly a political party controlled the General Assembly? Were they of any particular section of the country? Can you give us a little definition or?
Well, the main commonality among those 23 states is their willingness to make voting more restrictive and to make it more challenging for their citizens, and that in itself is a concern. The reality is that these 23 jurisdictions are across the country and are not defined by particular party control. So
there were some states that had Democratic Party control in the House and Senate both that passed these restrictions?
I believe so. We can go back and give you that information with specificity. But the main concern is the electorate's decision in those states to make voting more restrictive for those states. And that is a serious concern given the status of voting rights in this country as we documented it in this report, and given the history of this country and the degree to which those much more restrictive laws passed in a very, very short time period. So that's a new turn for us as a country, and it's fairly sweeping.
And the fact that we've gone from the more opprobrious pre-1965, how many seeds there are in a bottle or whatever, to more invidious types of discrimination, does that in any way diminish the need for Section 5 preclearance in the jurisdictions that have those type of voting limitations?
Absolutely not, Chair. I am astonished by what we saw around the country in the choices to denigrate voters' access and ability to vote on the basis of race, on the basis of disability status, on the basis of language access. There are an astonishing variety of ways that our electorates have chosen to make it more difficult for some among us to vote.
Mr. Science, let me ask you this. In California, you now have redistricting of the state legislatures, not of the county governing bodies, and those are the ones you specifically, I think, referenced in your testimony. Are they also mandated to take into consideration racial minority districts to try to create those in their redistricting when they're done by court order?
They're all covered by Section 2, which of course means if they have a pattern of racially polarized voting and the rest of the Senate factors, the totality of the circumstances indicate that there is vote dilution occurring, then they are mandated to create a Latino majority district in the context of racially polarized voting and the geographic concentration of Latino voters such that you can create a district that is compact, contiguous, meets all the usual criteria. And I can assure you that every one of those counties has legal advice about specifically the issues under Section 2 of the Voting Rights Act. I think in many cases they are in essence gambling, assuming that because of the expense and the time involved in a Section 2 challenge, they won't be the jurisdiction that's challenged. And as I indicated, in the course of this decade, 8 of those 9 counties that we identified as potentially violating Section 2, essentially their gamble has paid off so far because they have not been targeted for litigation. Now, Kern County, which was challenged by MALDEF, after very lengthy litigation and trial, it did result in liability finding against them at great cost, and that I think is something that's not often remarked about. The cost to the defendant jurisdictions under Section 2 litigation is substantial. If they were subject to Section 5 preclearance, their costs would be minimal in comparison. The Kern County Board of Supervisors ended up paying, it's a public number because it's a part of a settlement, $3 million to the plaintiffs for their attorneys' fees and expert costs. You can assume that they have equivalent and probably even higher costs of their own. They had to hire outside counsel, employ their own experts.
Let me ask you this. You think Section 5 is the most important section for enforcement?
Absolutely. It permits efficient
Ms. Lhamon,
and
do you agree with that?
I do. Its loss is very significant.
Mr. McCrary, can you tell us why Section 5 is so important and necessary, and while Section 2 exists for the country, Section 5 is important, the most essential part of the Civil Rights Act? Voting Rights Act, excuse me. Turn your mic.
With the way Section 5 operated before Shelby County, it gave quick decisions for jurisdictions about voting changes they were intending to make. And most of them were pre-cleared, and most of them within the 60-day clock that governs the operation of the pre-clearance review. It cost them practically nothing. Moreover, it served an educational function that the Congress recognized in 2005 and 2006 when it was building that voluminous record. There were some states covered by Section 5 that actually supported the extension of the preclearance process in 2005 and 2006, and that's part of the record before Congress. The reason was that it gave those states an opportunity to consider seriously the needs of minority voters, the views expressed by minority voters in the preclearance review, as well as the local jurisdictions' views, and to make better decisions about how to change the electoral process in those jurisdictions. But where jurisdictions were not so well intentioned, it was possible to object to those changes, and oftentimes when federal courts were asked to address this question, they reached the same conclusions as the Department of Justice. It was efficient, it was educational, it stopped things in their tracks that were going to be problematic, but for the most part, it did not interfere with the electoral process in those jurisdictions that were covered by Section 5.
Thank you, sir. And I now recognize the ranking member for 5 minutes, Mr. Johnson.
Thank you, Mr. Chairman. Mr. McCrary, Chris Coates is a former chief of the voting section of the Department of Justice. He testified before the U.S. Commission on Civil Rights about opposition within the Department of Justice to bringing a case under the Voting Rights Act because the victims of the discrimination happen to be white. According to the Washington Post, quote, Coates has a pedigree different from that of many conservatives. He was hired at Justice during the Clinton administration in '96 and had worked for the American Civil Liberties Union. Sheldon Bradshaw, a high-level civil rights division official in the Bush administration, said Coates is, quote, nonpartisan in how he enforces voting rights laws, unquote. Mr. Coates, in his testimony before the commission, said, and I quote, opposition within the voting section was widespread to taking actions under the Voting Rights Act on behalf of white voters in Noxubee County, Mississippi, the jurisdiction in which Ike Brown is and was the chairman of the local Democratic Executive Committee. What I observed on election coverage in Noxubee County was some of the most outrageous and blatantly racially discriminatory behavior at the polls committed by Ike Brown and his allies that I have seen or had reported to me in my 33 years plus as a voting rights litigator. A description of this wrongdoing is well summarized in Judge Tomley's opinion in that case and in the Fifth Circuit Court of Appeals opinion affirming the lower court judgment and the injunctive relief against Mr. Brown and the local Democratic Executive Committee. I'm continuing to quote him. Of course, there is nothing in the statutory language of the Voting Rights Act that indicates that DOJ lawyers can decide not to enforce the race-neutral prohibitions in Section 2 of the Act against racial discrimination. Here's the relevant quote. One of the social scientists who worked in the voting section and whose responsibility it was to do past and present research into a local jurisdiction's history flatly refused to participate in the investigation, unquote. The question is, are you the social scientist to whom Mr. Coates was referring?
The answer to that question, Representative Johnson, is yes. His testimony was, in fact, erroneous, as the Inspector General's report noted in a footnote. I, in fact, worked on that case. I was at trial in the case, and I will note that Chris Coates and I became friends beginning in 1980. I worked with him on voting rights cases as an expert witness. I encouraged the voting section to hire Mr. Coates in the mid-1990s. I worked closely with him on all manner of cases, including the case in Noxubee County, which in fact reveals egregious behavior by the political leaders of the black community in that county. The answer to the question is I was the person to whom he referred, but his information was false.
Fair enough. Mr. Chairman, in a recent paper, the U.S. Commission on Civil Rights, Commissioner Gail Heriot, in footnote 40, puts in context some of the examples used by the chair of that commission, Catherine Lhamon, claiming to show instances in which a right to vote was denied. I would ask unanimous consent that the paper be submitted for the record since Ms. Lehman's report has been submitted also.
Without objection.
Thank you. Ms. Whitaker, can you walk us through how a generic case would be brought under Section 2 of the Voting Rights Act and in what steps it would proceed?
Yes, thank you, Ranking Member Johnson, for that question. Section 2, as I said in my remarks, applies nationwide. It authorizes both the federal government and private citizens to challenge discriminatory voting practices. It specifically prohibits any state, as well as political subdivisions, from applying or imposing a voting qualification, practice, standard, or procedure that results in the denial or the abridgment of the right to vote based on race, color, or membership in a language minority. Furthermore, the statute provides that a violation will be established if, based on the totality of the circumstances, electoral processes are not equally open to members of a racial or language minority group, in that those members of that group do not have equal opportunity to elect, as compared to other members of the electorate, to elect representatives of choice. And as I mentioned, the vast majority of the case law with regard to Section 2 has been determined in the context of redistricting, but in recent years, we have some developing jurisprudence challenging other types of election laws.
I have time for one more question for you. Why does the Supreme Court require Congress to create a substantial record of the need for any sort of federal preclearance process before it upholds a federal statute that requires states and localities to get permission from the federal government before their voting rule changes can go into effect? Why is that so important?
Thank you, Ranking Member Johnson. The key case here for Congress in going forward is what the court said in Shelby County versus Holder in 2013. In that case, the court identified the principle of equal sovereignty among the states. And the court said that to comply with that standard requires a showing that a statute's disparate geographic coverage has to be sufficiently related to the problem it targets. According to the court, as I mentioned earlier, it criticized the data, the outdated nature of the data that Congress had relied on in reauthorizing the coverage formula, criticizing it from stemming from the late 1960s and early 1970s.
Thank you. I yield back.
Now recognize the ranking member for the chairman of the committee for 5 minutes, Mr. Nadler.
Thank you. Ms. Whitaker, my recollection is that when we held hearings back in 2006, we established a record of the need for the voting for Section 5 of the disparate impact as of then, not going back to 1994. How did the court disregard those findings?
Thank you, Chairman Nadler. The court acknowledged the extensive record that Congress created. However, the court focused on the fact that the coverage formula had not been substantively updated since Congress had last updated in 1975, and again, that it focused on those statistics regarding literacy tests and low voter turnout and low voter registration rates from the late 1960s and early 1970s.
Thank you. Ms. Lhamon, first of all, let me ask you a quick question, and then what I want to get to. Would you tell us what footnote 40 referred to and why it was wrong?
The footnote is part of Commissioner Harriot's statement, and it suggests that there may not be ongoing concerns about race discrimination among other discrimination in the states. The facts are what they are. For example, one of the examples that I highlight in my statement is an example in New York State where 30 Chinese American students were almost prevented from being able to vote on the basis of national origin because someone challenged their Americanness. And challenged their ability to vote. They ultimately were able to vote, but it was humiliating for them. There was testimony received from one of the students who said it was his first time attempting to vote, and he felt like he wasn't an American because someone suggested that he had no right to vote.
Okay. Now, you, Ms. McCrary, Mr. McCrary, you have written that the majority opinion in Shelby inappropriately focused on the evidence that voter participation had approached parity between whites and African Americans. Why is focusing exclusively on that statistic misleading? In other words, what does the statistic fail to capture that is relevant?
Are you asking about the data in the record before Congress or about the general focus on participation?
General focus. You said that
Yes.
inappropriately, you said that the majority opinion inappropriately focused on that data as opposed to more general data.
Well, as I said, a primary focus of the voting changes to which the federal courts and the Department of Justice objected over the decades was to vote dilution. And to ignore that fact seems to me an important lapse in the court's consideration of the record.
Okay, thank you. Ms. Lhamon, I have two questions, which I'll ask as one question. We know the basic problem before the Voting Rights Act and the basic problem with the Voting Rights Act after Shelby County is that Section 2 is difficult to use. You can lose your voting rights, and you play a game of whack-a-mole.
Right.
You've finally proven after 3 elections have gone by that this is discriminatory, and they enact something else that comes with the same thing. Two questions. Number one, why not amend Section 2 to enable a court to temporarily enjoin something, a practice, if there is any evidence that it might be discriminatory while the proceeding goes on, so you can't have 2 elections go by under discriminatory practice and then find it unconstitutional. So you stop the game of whack-a-mole. And second of all, why not get around all of this and apply Section 5 nationwide?
Well, taking the questions in order, it is the Commission's very strong recommendation that Congress amend the Voting Rights Act to be more proactive and to find ways to make sure that voters' rights are protected ex ante. So your suggestion is consistent with the Commission's recommendation and would be helpful. It is my own view that fix would be an important fix, and it is also important to give life to the Section 5 protections, which already were designed to be those kinds of ex ante
So why not make Section 5 nationwide under congressional power to regulate federal elections or any elections, as the courts have found, that affect federal elections?
Chairman, it is very clear from the evidence that we gathered that there is support for a need for that kind of protection nationwide. The United States Supreme Court gave clear guidance to Congress that it needs to have current basis for the kinds of harm, and we found that basis in our investigation. About
the Supreme Court said that we have to have current basis for discriminatory among different for discriminating among different sovereignties. If we didn't discriminate among any sovereignties, we said everybody's subjected to Section 5. What's the argument again? Is that a good idea?
Well, Congress certainly has the authority to enact the laws that it chooses to enact, and it would be even-handed in its protection, and in that sense consistent also with a different sentence in the 2013 decision from the United States Supreme Court. It is my view that a belt and suspenders approach is appropriate, and there's an absolute basis.
What do you mean by a belt and suspenders approach? I'm sorry.
That it's important to shore up the basis for congressional action.
So you think that would be a good idea?
I think it would be a good idea to shore up the basis for congressional action, and there's no question that there is strong evidence across the country of contemporary discrimination with respect to access to voting.
Okay, my time has expired. I yield back. Thank you.
Thank you, sir. We now recognize Mr. Jordan from Ohio.
Thank you, Mr. Chairman. Ms. Lhamon, do you believe that non-citizens should be able to vote in federal elections?
I think that's up to the electorate to decide.
But I'm asking you, as the head of the chair of the U.S. Commission on Civil Rights here testifying on the Voting Rights Act, what do you believe?
Well, Member Jordan, I couldn't answer that as the chair. My personal belief is that I enjoy voting today in a community where non-citizens are able to vote. But that's unrelated to what the commission would vote on together.
My question's real specific. What do you believe non-citizens should be able to vote in federal elections?
It's not a question that I've given a lot of thought to. They are not able to vote now. Congress hasn't given them that authority.
I understand that. But you said you're in a community where they can vote in local elections, is that right? And you support that?
I enjoy my right to vote, and I don't question what my fellow voters have decided.
Mr. Sands, same question. Do you believe non-citizens should be able to vote in federal elections?
No, I don't believe non-citizens should be able to vote in federal elections. I do believe that in local elections, particularly in the school board elections, where non-citizens' children may be the most heavily affected by decisions by those who are elected, that it is appropriate to consider providing the vote to non-citizens.
Why don't you think it's appropriate? I'm just wondering what you're thinking, because it sounds like Ms. Lhamon may think it's appropriate for non-citizens to vote in federal elections. You were clear and said you don't think that should happen. And why don't you think that should happen?
Because I think that we should encourage folks to naturalize and become citizens so they have the full scope of rights that are involved in citizenship. Voting is one of them, but not the only one. So I'm in favor of streamlining our naturalization process and ensuring that everyone who's eligible has the ability to apply for and receive citizenship regardless of their financial circumstances, for example.
Do you think allowing non-citizens to vote in a federal election would devalue the vote of citizens?
No, I don't think it would, but I think it would devalue the process of becoming a citizen for those who were not born here.
Dilute and devalue the vote of citizens?
I don't.
I don't know how, well, it seems just logical that if
But you and I
only
disagree.
citizens, if only citizens are allowed to vote,
For me to accept,
non-citizens voted, that would devalue the vote of the citizen.
I don't see it that way, Mr. Jordan. I think that depends upon how those non-citizens vote in comparison to citizens. I simply have no information about that. So I can't accept your premise that it devalues someone else's vote that another person votes. That's a very dangerous proposition. It would suggest, as we allow more and more people to vote, that somehow they're devaluing the votes of those who voted previously.
I'm all for more people voting as long as they're citizens. Mr. McCrary, do you believe that non-citizens should be able to participate and vote in federal elections?
No, but I would note for the historical record that restrictions, the restriction of the right to vote to citizens dates from roughly the turn of the 20th century. Throughout
I understand when it happened.
18th
I'm asking
and
today.
19th centuries, non-citizens were freely encouraged to vote, but
It's a little different country in the 1800s.
I'm sorry?
A little different country in the 1800s, Mr. McCrary. I know the law. I'm just asking what you believe should be the law today.
Representative Jordan, I answered the question to begin with. The answer is no.
Do you believe it devalues if non-citizens would vote? Do you think that would devalue the vote of the citizen?
As an abstract theoretical matter, you're correct that there would be a devaluation.
Of course.
But it's not likely to be a significant empirical problem.
Yeah. Okay, so if it would devalue, you think only citizens should be able to vote, and if non-citizens did vote, it would devalue the vote of the citizen. Are you in favor of some kind of identification and proof that the voter has to present when they vote to demonstrate that they're actually a citizen?
Only at the registration level, Representative Jordan. When you require extra identification processes for in-person voting, it can serve as a restrictive procedure. It slows down the process. It makes people nervous about.
So you're against a photo ID? You're opposed to a photo ID?
I'm sorry?
You're opposed to any type of photo ID presented at the polling station when an individual goes to vote?
Yes. The record before the courts that have addressed this question is universally that there is no problem with in-person voter fraud in this country. And the use of a photo ID requirement actually has been demonstrated to have a discriminatory effect on minority voters in every case where it's been addressed.
Okay, I got 15 seconds. I want to give Ms. Whitaker a chance to answer the same questions. Ms. Whitaker, do you believe non-citizens should be able to participate in federal elections?
Thank you for that question, Congressman Jordan. CRS does not make policy recommendations, and non-citizen voting is outside of the scope of the testimony that we were asked to prepare, but we'd be happy to research that for you and get back to you.
Okay, thank you.
Thank you.
Thank you, Mr. Jordan. Professor Raskin is recognized for 5 minutes.
Mr. Chairman, thank you very much. Thanks to all the witnesses for great testimony. Ms. Lehman, let me ask you. United States District Court in Texas struck down a draconian voter ID law that Texas had imposed on the people of Texas. But in the meantime, elections took place where there was a U.S. senator elected, 36 members of this body were elected, the governor, the lieutenant governor, the attorney general. And what is the remedy for that? This election took place under conditions where lots of people were deterred from participating. Their right to vote was chilled. What was the remedy under Section 2?
There is no remedy. There is no way to restore voting rights to people who now live with elected officials.
Well, isn't that the decisive argument against neutralizing Section 5 of the Voting Rights Act? Section 5 is all about pre-clearance, making the jurisdictions send the plans in advance to the Department of Justice or to the U.S. District Court in D.C., right? And if a state is permitted to get away with violating the Voting Rights Act and elections take place under it, there's no remedy, right?
That's right.
Okay, let me ask this question. Should Section 5 be amended to allow private parties to challenge the findings of the Department of Justice? The Supreme Court held that the DOJ couldn't do that, or rather that states couldn't object. Should states have the power to do that? Mr. Sands, what do you think about that?
I think it's something worth considering simply because it then takes the benefits of Section 5 preclearance in a more efficient and effective way of reaching a timely conclusion and adds the additional element. Right now, under a previous preclearance regime, you would have to follow up with a Section 2 case. It would be much more efficient to have a Section 5 related cause of action.
Okay, and what is your response to Chairman Nadler's question about whether it makes sense at this point just to amend Section 5 to say we're not going to try to figure out which state bears the most guilt at this point under the Supreme Court's unbelievable outburst of judicial activism where they declared basically an equal protection act between the states, which didn't exist. But in any event, now that's the straitjacket we're laboring under. Why not just say all the states have to pre-clear voting changes with the DOJ first? What do you think of that?
I'm in favor of a hybrid of both. I think there are certain practices, for example, reverting from district elections to at-large elections that are on their face questionable and have been used in the past to restrict voting rights, and those kinds of changes should be subject to the very effective and efficient pre-clearance mechanism nationwide. On the other hand, there are clearly jurisdictions that have an ongoing history of discrimination in voting, of attempts to restrict the right to vote with respect to particular minority groups, and those jurisdictions, despite the second guessing by the Supreme Court justices of this body's conclusions, those jurisdictions should be subject to preclearance more broadly.
Well, the Civil Rights Act or the Pregnancy Discrimination Act or other civil rights statutes apply nationally, even though we don't necessarily have a factual predicate to prove that there's a problem in a particular state. Why not just make it nationwide and then avoid another outburst of judicial activism on the part of the Roberts Court?
So my only concern there is subjecting everything to preclearance nationwide would present a bureaucratic snaggle that could prevent getting an efficient and quick response where necessary. So that's why I'm in favor of a hybrid. Particular practices, yes, nationwide preclearance, specific jurisdictions subject to broader preclearance on all electoral changes.
Okay, very good. Now, my friend Mr. Jordan's left the room, but is there anything in any of the legislative proposals you've seen to overcome the Supreme Court's decision in Shelby County versus Holder, which would give non-citizens the right to vote in federal elections?
Not aware of anything ever been suggested.
Is anyone on the panel aware of anything in any of the suggested proposals that would give non-citizens the right to vote in federal elections?
I am not.
Okay, well, let me ask this question. Are you in favor, let's start with you, Mr. Sands, of the federal Congress striking down local laws across the country that may allow non-citizens to participate in local elections like school board elections?
No, I think that's a decision that should be made at the local level.
In other words, if you respect federalism, you would say that's got to be up to the states and localities to figure it out, right?
Absolutely. This body has control over federal elections quite clearly and limited control over other elections, but that's a decision should be left at the local level.
Okay, and one must charitably assume Mr. Jordan's ignorance of the fact that non-citizens could vote in local and state elections for the vast majority of American history, and it was his party, the Republican Party, which was the great champion of that, and Abraham Lincoln actually was accused of winning election in 1860 based on the strength of the non-citizen vote. So all of that seems to be a great red herring, and I would urge Mr. Jordan to study the history of his own party because this became an issue in the Civil War, and it was the Republican Party which stood up for the right of non-citizens to vote. I happily yield back, Mr. Chairman.
Thank you, Mr. Raskin. Mr. Klein is here. I don't think he has a question at the present time, but I want to commend him for being here to listen. That's an admirable and unusual quality for a congressman. Ms. Scanlon, you're recognized.
Thank you very much. Mr. McCreary, I think you just fielded a question from the gentleman from Ohio about whether it would devalue the vote of citizens to allow non-citizens to vote. I'd like to flip that a little bit. Does it devalue citizenship if citizens aren't allowed to vote for representation in Congress?
I'm sorry, could you repeat the question? I'm not sure I understood it.
Sure. We had some questions about whether it devalues citizenship if non-citizens are allowed to vote, but I'd like to focus for a minute on the fact that citizens of D.C. and Puerto Rico and the territories are actually U.S. citizens, but that citizenship does not allow them to vote in congressional or have representation, voting representation in Congress. Does that impact the value of their citizenship?
The only part of that question on which I've done any serious research is the fact that Puerto Ricans, when they come to the United States, are automatically able to vote because they are citizens, and they immediately assume a role as participants in the electoral process.
Okay, thank you. Just with respect to voting rights, I represent Pennsylvania, so not a Section 5 state, but we do have our own challenges. And I'd like to focus for a minute on one that's been particularly prevalent in the districts I've represented. Back in 2010, we had an issue involving Lincoln University, which is a historic black college and university, located in a predominantly white township, and our local election officials moved the polling place from the HBCU to a less convenient place, and that impacted the ability of the African American population close to the university to vote. Is that the kind of thing that the Voting Rights Act was designed to address, Ms. Lhamon?
It absolutely is, and it's the kind of thing that we see very serious concern about all over the country still today.
Okay. In fact, just this year, we had an issue involving Haverford University, also in my district, where the university had a substantially younger, more diverse population than the surrounding area, and we had a lot of difficulty getting a polling place there. Can you make any recommendations as to what we could do with the Voting Rights Act to address those issues?
Yes, it's very important for Congress to ensure that the Voting Rights Act is amended to allow for ex-ante resolution of those kinds of issues, just to make sure that voters are able to vote in upcoming elections, don't lose their right to vote because of decisions to move a polling place, to close down polling places. It has very, very significant impacts. We saw, for example, testimony from the Alaska State Advisory Committee about an Alaska Native elder who had to walk 2 miles to be able to get to a voting place that was open.
Okay, thank you. And just with respect to the bill in general, in my prior life, I participated with the Lawyers Committee for Civil Rights and the National Commission on Voting Rights on building the extensive record about the continuing issues that the Voting Rights Act was designed to address. So I'm very, very interested in seeing us amend the Voting Rights Act, reauthorize the Voting Rights Act to continue. So thank you.
Thank you.
Mr. Armstrong's here as well. Would you like to question?
Thank you, Mr. Chairman.
You're recognized for 5 minutes. Mr. Armstrong from North Dakota.
Talking about pre-clearance and how we're dealing that, in theory, there's a theoretical application, and then there's an on-the-ground application, particularly in rural states. North Dakota is unique. It's the only state in the country without voter registration. It's also incredibly rural. We have entirely vote-by-mail counties and different issues. So my question, and probably for Ms. Whitaker, is what kind of evidence has the Supreme Court used in the past to require pre-clearance on voting rules?
Thank you, Congressman. Under Section 5, the pre-clearance requirement of the Voting Rights Act that was in effect prior to Shelby County, the covered jurisdiction had the burden of proving that the proposed change to the voting law or standard was neither enacted with a discriminatory intent, and that it would not have a discriminatory effect if it were to be imposed or enacted.
And has Section 3, I think I can ask it for both Hispanics and Native Americans. Obviously in North Dakota, Native Americans are more prevalent than Hispanics, but has it been used to protect voting rights of Native Americans in the past?
Section 3C has been used. CRS has not independently verified this research, but roughly, according to the legal scholarship in this area, 20 jurisdictions have been bailed in under Section 3C. I'm not in a position to verify specifically whether Native American, a case involving Native Americans was involved, but I would happy to do so and get back to you.
Well, and since I have 3 other people, if any of them are aware of it, I would take that answer as well.
It has, and also I just want to take the opportunity to mention that the North Dakota State Advisory Committee to the U.S. Commission on Civil Rights issued a statement in October raising very serious concerns on this front about North Dakota Native American voting rights access. It in pertinent part says the North Dakota Advisory Committee is troubled that this restrictive voter ID law targets Native Americans, the largest minority group in the state, constituting 5.5% of the population. The committee's primary concern is that the law may deny eligible voters access to the ballot, and it goes on from there, raising very significant concern about Native Americans' rights in North Dakota.
And actually that was due to a court decision that without voter registration, there's been significant voter ID laws and different issues that go on. You will be happy to know that the turnout on the Native American reservations in North Dakota into the 2018 election was the highest it has ever been, presidential or non-presidential. And so
I am happy to know that.
Hopefully we can continue to work that forward as well.
I am happy to know that, and I also know from the North Dakota State Advisory Committee's work on this issue that it followed very serious organizing among the Native American communities, which puts a set of pressure on those communities that we would hope that federal law wouldn't require.
I yield back the rest of my time.
Thank you, Mr. Armstrong. Ms. Dean, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I'm Madeline Dean. I come from Pennsylvania, and I think about Pennsylvania, and we are the poster state for some good things surrounding voters' rights and some very bad things. 2 weeks ago, I had the pleasure, the extraordinary historic pleasure of traveling with Representative John Lewis to the Edmund Pettus Bridge, to Selma. And as we came back down the bridge, my husband stood at a plaque, bronze plaque memorializing the Voting Rights Act. And right across from it, right next to it, was a canvas that said, "Lift our vote, 2020, voting rights under fire." It was a jarring comparison, and it's a reminder of our history, that our history is not so long ago. And as you point out, the history is actually continuing in terms of voter discrimination. When I was first elected to the Pennsylvania House in 2012, so this is pre-Shelby, but we are also not a Section 5 state. You might remember that the Pennsylvania House in March of 2012, with Governor Corbett signing it, passed a voter ID law. I was a brand new representative in May, came in a special election. We spent the next year and a half going to old age homes, trying to help people get qualifying identification, sitting with women, men who were 85, 90 years old who said, "I have voted for the last 60 years. I can't believe I don't have a birth certificate. I don't have this." So the chaos and confusion which ensued from that piece of legislation until it was overturned as unconstitutional in, I think, January 2 years later, was costly to people. So I wanted to ask you, in kind of plain language, for those who haven't read Shelby, don't understand what Section 2 does versus Section 5, what is at stake? You've pointed out that voting rights are at stake. What is at stake, and what should we, this committee, in terms of crafting new legislation to fully, robustly support our voting rights, what should the American people know about what's at stake in terms of voting rights?
Congressmember Dean, that what is at stake is our very American self-concept. We believe in a country that is based on full participation and responsive government to its citizens. If we can't all vote, if we can't all fully participate, then we are not a true democracy. That is what is at stake.
Thank you.
It's the right to vote as you've described it, from the new voter, very eager, just getting out of school, wants to participate in democracy, who may face barriers, untoward barriers to that right to vote, to the long-standing voter who's voted for decades without any problem, but who, because of new attempts to create barriers to voting, may not have the ID that is now required to vote, may not know where the polling place that they voted for decades has moved, may not understand the new requirements to participate in the ballot. It is the right to vote that every citizen enjoys and should enjoy in a democracy.
Professor?
The problem you refer to is one that we encountered routinely in the cases challenging the use of a photo ID requirement for voting, in-person voting. And you illustrate through your anecdote, based on your personal experience, why the photo ID is so difficult for some American citizens. Specifically, birth certificates are not universally available. Many people of an older generation were born not in a hospital, but at home or under the care of a midwife. They never got a birth certificate. Moreover, people who have birth certificates but have moved to a different state sometimes have difficulty in getting a copy of their birth certificate if it's been misplaced or lost. There are all sorts of reasons why a photo ID requirement is a restriction on the voting process for some 10%, depending on which state you're in, of the voting age population that is registered.
I appreciate that. And if you remember, this was 2012, so the corrosive underbelly of what spirited that legislation was revealed very openly by then leader Turzai, now Speaker of the House Turzai, who famously said, "Voter ID, which is going to allow Mitch Romney to win the state of Pennsylvania, done." You saw that over and over again, that was obviously the spirit of that legislation. In the litigation, you remember it was stipulated that they could not come up with a single case of voter fraud through false ID or acting as though they were someone else. So the political underpinnings of it. I guess as we go and move forward to craft legislation, what can we do to not only protect the Section 5 states, but states like mine?
I think there's two things. First, we should all recognize that Section 5, when it was in effect, did help non-covered jurisdictions at all because there was an indication of what the Department of Justice concluded was problematic, and the non-covered jurisdictions learned from that. But I also believe that the Congress should seriously consider a hybrid coverage formula that would include coverage of certain changes that have a history that is suspect being pre-cleared all across the country.
That's really helpful. Thank you. Thank you, Mr. Chairman.
Thank you, Ms. Dean. And Ms. Garcia, I think you're next. Texas.
Thank you, Mr. Chairman, and thank you to all the witnesses. And it's been sort of a interesting period for me listening to you because it brings back a lot of bad memories. Because quite frankly, well, some say they're the poster child for what happens good in elections. Unfortunately, I'm from Texas. And as you know, some of the leading cases on the barriers, the bad stuff that happens in this arena do come from Texas. And well, we like to brag about a lot of things. Obviously, this is not one that I like to brag about. And I want to start with you, Mr. Sines, because I know you and I have worked together in a number of cases. And I still remember calling MALDEF about the Pasadena case because we needed your help. Because frankly, my district and my area is sort of ground zero for some of the litigation that has spurred out in Texas. Not only the Pasadena case, but you remember the Lake City case, the San Jacinto College case, Pasadena School Board case, the Galveston case. It's all happening there. And I guess my question is this. It seems to me that all this has done is do what a lot of conservatives always argue we don't want to do is litigate, that we're just giving work to the lawyers, that we're all about litigation. But that's all that's resulted, hasn't it? Because if you look at what's going on now without the Section 5 preclearance requirement, there's no other way to do it. But why should we have to do it? It would be better to do the preclearance in the hybrid form as you suggest, or going back the way it was, because then we would avoid all that. I mean, the costs incurred, how much do you think it has cost us, just ballpark figure, in terms of resources and lawyers and litigation, and not to mention what the litigants have to go through, the petitioners?
It's hard to estimate, but I would say we are talking in the tens or hundreds of millions of dollars that have been expended on litigation that could have been avoided if we had preclearance in place. Pasadena, Texas is Exhibit A, because that is a case that was precisely created through a change that the mayor knew he could obtain without preclearance, but understood had preclearance applied, it would never be approved. So we could have avoided that litigation had preclearance still been in place. And that litigation was very costly to the city of Pasadena, Texas, and its taxpayers, because they not only in the end had to pay their own attorney's fees and expert costs and other costs of defending, they had to pay the plaintiff's fees and costs of litigating the case. So you're doubling the cost of expensive litigation that could be avoided, which is why I characterize preclearance as one of the most effective alternative dispute resolution mechanisms this Congress has ever put in place.
Right. So tell me, the other thing that I've noticed about all of this litigation, that it just seems like the burden is just so much harder to prove the intentional discrimination factor. It really puts such a high burden on the petitioner, whereas under Section 5, you could file the complaint, and again, Texas was probably number one in the number of complaints. And what is there anything that we can do in terms of a change in law to help with the burden of proof, to help with the litigation, to make sure that at least it doesn't take us long?
The totality of the circumstances test, and that's how the Supreme Court has described it under Section 2, is a wonderfully contextualized test. It enables you to look at all of the different factors occurring in a community. But the flip side of that is that it is very expensive. And if you then have to prove intentional discrimination in order to obtain a bail-in order or requirement that the jurisdiction be subject to preclearance, as we did in Pasadena, Texas, as you've indicated, the cost goes up even more. The burden for the plaintiff goes up even more. So anything that can be done to identify the prevailing patterns and somehow streamline the ability to get in and change those prevailing patterns, and preclearance is the best mechanism for that. It's available to us if the Congress will respond to the second guessing by the Supreme Court majority and enact a new coverage form.
Thank you. And now, Ms. Lhamon, something you said caught my ear. You said in the response to one of the questions that there was no question there was discrimination in access to voting. Now, is that an official finding of the commission, or is that just your opinion? Or if it's true, then why are we having all these debates if there's no question?
It is official as a finding of the commission, and we voted unanimously to support those findings.
And when was that, ma'am? I'm sorry, I don't.
We issued the report in September 2018.
Okay.
And the very comprehensive investigation of the commission includes documenting places all over the country where people with disabilities are impeded in their ability to vote, where people of color are impeded in their ability to vote, where people with language access challenge are impeded with their ability to vote. That the access to the vote is very much under siege in this country now. And that is the conclusion of the U.S. Commission.
But you looked at voting, not the registration, not any of the other, just actual voting, access to the ballot, the day of the election.
Yes, we did. So we took in testimony about people who physically couldn't access their polling place because the polling place wasn't accessible to people with disabilities. We took in information about people who tried to vote on the day of and were turned away. For example, the Kansas State Advisory Committee took in testimony from Native American voters who brought a Native American ID and were turned away at the polling place because although state law allows voting with a Native American ID, poll workers at the polling place didn't understand that and so turned a voter away. There were serious access issues that we documented around the country.
Well, I suggest you send a copy of the report to the White House. Thank you.
Thank you, Ms. Garcia. And Ms. Escobar from El Paso, Texas.
Thank you so much, Chairman. And Chairman, thank you for your references in your opening remarks about Congressman John Lewis. I had the incredible privilege of being with Congressman Lewis and other members of Congress recently as we marched across the Edmund Pettus Bridge in Selma, Alabama. And at the very top of the bridge, Congressman Lewis recalled to us in painful and excruciating detail the journey that he has been on and the journey that led to Bloody Sunday, all to fight for the vote. All to fight for the vote. And so that opening was really poignant, and I'm very grateful for it. And I'm grateful to all of you for being here today and sharing your expertise and the work that you have done in your careers, especially Mr. Sines, thank you. As a Latina, I am so grateful to you for the work that you have done, the work that MALDEF has done. But thanks to all of you for sharing your time here today. This past September, the U.S. Commission on Civil Rights released a report analyzing minority voting rights in the United States following the Shelby County decision. The report found that our home state of Texas has the unfortunate distinction of having, quote, the highest number of recent VRA violations in the nation, end quote. Further, the report details that Texas implemented one of the strictest voter ID laws in the nation after Shelby County was decided, the very same law that a federal court deemed retrogressive just a year earlier. In fact, Governor Greg Abbott, who was Texas Attorney General at the time, tweeted 2 hours after the Shelby County decision that the voter ID law would be reenacted. Mr. Sines, can you please give us some examples of new voter suppression mechanisms that would have been prevented by pre-clearance?
Absolutely. You know, in your state, we are currently going through Voting Rights Act litigation. Indeed, yesterday, MALDEF lawyers were in court related to the voter purges that have been threatened for almost 100,000 registered voters in the state of Texas. Why? Simply because they are naturalized voters. They are naturalized citizens who then registered to vote, but prior to naturalizing, they submitted to the motor vehicles an indication that they were not yet citizens. But those are nearly 100,000 voters who were threatened with the prospect of being removed from the rolls. And even if no action is ultimately taken, as we believe will be the case, the litigation so far has been successful, that is a discouragement, a deterrence to so many in the state of Texas, naturalized or not, from participating in voting. And I think that was the intent behind a huge announcement, knowing that the data was faulty, by the Secretary of State, joined by and repeatedly reinforced by the Attorney General. We also have the example of Pasadena, Texas. You would think, after a victory against Pasadena, where the city reverted from districted city council seats to a combination of districted and at-large seats, that we would see the end of that. But we currently face an issue in Odessa, Texas, where there is a similar proposal moving forward, this time by residents of the town, not the city council itself, that we have to grapple with. So there are really weekly, daily challenges to voting. One of your colleagues mentioned polling place relocations and consolidations, and you know, in the state of Texas, particularly with the number of counties that you have, that is a major problem with every election. And under Section 5, when those changes had to be pre-cleared, we at least became aware of what consolidations and relocations were being proposed. Now we don't even have that opportunity to know until the election is approaching, where a relocation may prevent Latino and other minority voters from participating at the same level as they have before. And that's just a single measure of what we've lost as a result of the Shelby County decision.
Thank you. Ms. Lhamon, what can Congress learn from Texas? Are there any characteristics that are risk indicators for voting discrimination?
Loyola law professor Justin Levitt testified to the U.S. Commission on Civil Rights about Texas, that Texas is, quote, an unrepentant recidivist with respect to voting rights. And I think that's what this body could learn from Texas, that there is repetition and over and over again around the country, in Texas, among other states, in the goal and the attempt to deny some of us our right to vote. That is a history that extends all the way to the present, that includes intentional discrimination as found by federal courts in Texas. That lets us know that we cannot turn away and assume that our voting rights will be protected just because we promised. We have to believe and know and act accordingly, expecting that some among us, as Texas has shown it will do, will try to deny the vote to some people.
And it is what Chairman Nadler described as this endless game of whack-a-mole.
That's right.
That as soon as you feel as though you've advanced just a little bit and done what Congressman Lewis has said or described as open it up to everyone. Let everyone have the vote. Let them have their right to vote. That as soon as it's denied, sure enough, before you turn around, we're fighting it again.
That's exactly right, and my only amendment to that would be that it is not a game to have access to participation in democracy, to be fully recognized as a citizen and a full participant in this country. That is something that is core to who we are, and we ought to protect it with that vigilance.
Right. It's in Latino communities, especially in communities that are largely immigrant communities, it is intended also to send a message, a very strong message. Mr. Sines, you're nodding your head. What do you think that message is?
It's intended to prevent people from participating. It's intended to prevent people from taking the right that they have and the duty that they have in exercising it. It's intended to send a message of deterrence. So even if you successfully stop something in the courts, it's already had that effect of sending a message from the highest levels in the state of Texas that your participation is not wanted.
Thank you all very much. I yield.
Thank you very much. I'd just like to ask one question of the panel. and maybe Mr. McCreary as an historian or Ms. Lhamon. In the pre-clearance states that we had, I think in '65, Alaska was included, and maybe, was there another, Alaska and Arizona were two states outside the South, but the other states went kind of like the old Confederacy. It was Texas, Alabama, Mississippi, Louisiana, Georgia, South Carolina, and then Virginia. Has there been more of a history over the years and up to today of laws that discriminated against minorities in southern states than in other states? Mr. McCreary?
Yes, but I thought you were asking me about the bailout provisions that got Alaska and other states out of coverage almost immediately after the 1965 Act was adopted. But certainly there's a record that's much greater for covered jurisdictions back in the day before 2013. I actually did a declaration in the Shelby County case in which I looked at all of the consent decrees that were settled in Section 2 lawsuits that were reflected in the court records under the PACER system. And there was a marked disparity in the number of lawsuits brought under Section 2 that were settled by consent decree in the covered jurisdictions. My recollection is it was 2-3 times as many as in the rest of the United States, the 3/4 of the population that lived in non-covered jurisdictions. But of course, the record of Section 2 lawsuits in reported cases also reflects a disparity between the covered and non-covered jurisdictions, so that the answer was, even if you're restricted to reporting decisions, reported decisions, you would find that discrimination in voting was greater in the covered states, covered jurisdictions, than in non-covered jurisdictions.
And Ms. Lhamon, is that what you found too?
Without question, the history that you describe does track to the southern states, but your reference to Alaska is apt in that Alaska is one of the states that we document in the report has repeat violations of voting rights and is well outside the South. We also took in testimony and information about very serious concerns about states that are not southern states with very current issues with respect to voting. Just to highlight or lowlight a particularly salient example, very recently in Maine, the then chair, he's no longer the chair, but the then chair of the Republican Party complained about dozens and dozens of black people coming into Maine to vote as a way of saying that there must have been fraud in Maine. This is well outside the South, but obvious racialized charge about voting access issues in the state. So I have been enormously distressed in the Commission's work to investigate the status of voting rights about the repeat concerns in southern states, but equally distressed about present concerns well outside the South, across the country, denigrating the right to vote.
And I understand and I concur in that concern, but what I was concerned about in Shelby v. Holder is what the court was basically saying is that because there are problems in other parts of the country, which there are, most of which are localized, not statewide, and more limited, that they threw out the pre-clearance for the southern states that have shown a great history going back as far as history goes in our country of discrimination, and they gave them a free pass because of concentrating on a small part. And as I was learned as a child at a donut shop in Miami, keep your eye on the donut and not on the hole. And that's where they messed up.
Very sage advice.
I think there are probably some significance that the anthem Dixie, which is so prevalent and popular in the South, says old times there are not forgotten. And they're
There's
not
some other
forgotten
lines I
with
like
voting
less in that
rights.
song, but that's a good one.
They're not forgotten with voting rights. Mr. McCreary, would you tell me about the bailout provision? Because that's news to me.
The bailout provision or the bail-in provision?
Whatever you said you thought I was going to ask you.
Oh, about bailout. It was a small point that in the initial phases of enforcing the Voting Rights Act, several states were able to bail out of coverage because the formula had picked them up, but there was no evidence on the record that they had a history of racial discrimination affecting voting. Of course, subsequent to that, there have been lawsuits in several of those states. And in fact, I think at least one state was added back into coverage not too long after the 1970 Act was revised. So, that's a small point I thought you were leading up to that confused me. But as to the bail-in provisions set out in Section 3C of the Voting Rights Act, one thing that's important for the committee to remember is that it requires proof of intentional discrimination and a judicial finding about that intentional discrimination. And even where courts have found intentional discrimination, such as in the North Carolina case to which I referred, the court did not, in fact, impose a Section 3C remedy. One way of dealing with the problems the committee has expressed concerns about might be to think about revising the Section 3C provision of the Voting Rights Act.
Thank you, sir. Mr. Silence, you want to say something?
Yeah, I just wanted to say bailout is critically important, and the Supreme Court majority in Shelby County failed to accord the bailout provision sufficient attention. It means that while history is predictive, so the history in the South is predictive of what's going to happen, we've seen it post-Shelby County. That's where the activity is in previously covered jurisdictions. So history is predictive. Recidivism is real in the context of voting rights violations. But where a jurisdiction, whether a state or a smaller jurisdiction, can demonstrate that they are not following their history, they are turning their backs on a history of violating voting rights and ensuring that everyone can participate, the bailout mechanism permitted them to seek relief from preclearance in the future. And I think that's critically important. It means that while history is a very strong predictor, if you can demonstrate you're not following that history, you get the opportunity to no longer be subject.
And which states and at which time has that occurred?
So as Mr. McCrary indicated early on, there were states that bailed out. Later on, Mr. McCrary would know the states.
Which states bailed out?
Alaska, I think Arizona. I can't recall any of the other states.
So it left it with the Dixie, whatever, the South.
Well, remember, there were also smaller jurisdictions around the country, and some of those smaller jurisdictions bailed out. So.
But no states. So the only states that were left in were those in the South. Is that correct, Mr. McCrary?
Yes, until later revisions of the Act in which some areas of New York were covered. And
areas, but not a state.
Pardon?
Not a state, only areas.
Not a state.
Right. Okay. Let me add one last question. And Mr. You talked about, Mr. Science, about the idea of having a two-pronged test, and one is the old preclearance, and the other would be mechanisms. Congress would have to determine what procedures or processes would fit into that class. Does it not concern you as it concerns me that we might not be looking at the whole and not the donut again, and we give the Supreme Court another reason to possibly throw out our law because we haven't done to their satisfaction a sufficient test to define those areas or to limit them to the ones that are most germane, and maybe even throw out Section 5 entirely?
I think that there are strong indications with respect to certain practices that there have been voting rights violations so inherent in some of those practices that a record could be created. Indeed, I think we've got the record for particular practices. It is a limited number. What are those practices? The one example that I gave was a jurisdiction that chooses to revert from districted to at-large. Ordinarily, that is done to prevent a minority group from controlling the majority of the body, for example. That's what we saw in Pasadena. We're seeing it in Odessa. We are seeing it in many jurisdictions across the country. Usually it doesn't go that direction, back to at-large. Now, there could be a reason why that would be pre-cleared. Maybe the jurisdiction is reverting to at-large because it's shrunk so much. It's a much, much smaller city than it used to be. But that, I presume, would be pre-cleared. But I think that there are a small number of practices where a record exists to support subjecting them to pre-clearance, an efficient and effective way of evaluating their potential for violating voting rights across the country. I don't think it's a huge list of practices. I do think that it is a way of ensuring that we are using this powerful alternative dispute resolution mechanism as effectively as possible. As I've said in public speeches, when you talk about vote suppressors, you want to target the serial vote suppressors, that's the Deep South, but you also want to target the copycat vote suppressors who adopt the tactics of those for their own means.
Thank you, sir. And with that, we'll conclude our hearing. I want to thank all the...
Mr. Chairman, I'm enjoying using the 10-minute rule, but I'd like to have at least 5.
Sure, Mr. Gomer, I didn't see you there. Mr. Gomer from Texas is recognized for 5 minutes.
Thank you. It's interesting to hear all the talk about the discrimination. As I recall, when we had the Voting Rights Amendment or Act reauthorized, it was clear to me that it was going to be unconstitutional. I talked to deans from some very liberal law school, constitutional law professors, and they all said this is not going to stand up because you can't keep punishing states for activity 50, 60 years, 50 years or so before. And the amendment I was trying to get passed that a majority voted down said, let's apply Section 5 anywhere discrimination is found. But the majority said, no, we want to keep punishing areas that have been found to have violated civil rights 40, 50 years ago. We want to keep punishing them. And we had data that showed that there were areas around the country, not whole states, but there were areas, I think there was an area in Wisconsin, California, in New England, where there was great disparity in the voting records indicating strong indication of racial discrimination. And yet people that were members of the House from those states absolutely were adamant you cannot open up Section 5 to states that are not part of the traditional former South because we don't want to be included. There was no way that was going to stand up. I brought it to the attention of a Republican ranking person at the time, Jim Sensenbrenner. He didn't want to hear it. He didn't want it included. Of course, he was from Wisconsin. John Conyers, as chairman of the committee, was much more open to talking about it. He said, let me talk to our experts. And anyway, he came back, said, yeah, they tell me there's a chance it could very well be struck down, but we'll go ahead and run that risk. Well, it got struck down. Ms. McCrary, Ms. Whitaker, in your research, I know we heard mention of Section 3C, Section 3. In your research, has Section 3 ever been used by a federal court to require jurisdiction to pre-clear their voting rule changes?
Thank you, Congressman Gomart. Yes, our research has indicated there have been instances where the bail-in provision in Section 3C of the Voting Rights Act has been used to subject a jurisdiction to a type of preclearance.
Okay. And I noticed at the Democratic National Conventions where voting is so important, you know, was it like last, was it going to be Bernie Sanders? Was it going to be Hillary Clinton? There were complaints, you know, of cheating to keep Bernie Sanders from being the candidate, all these kind of issues. But I noticed around, and we have photographs, around the convention site, there were huge barriers, fences, and I know going back to at least 2008, when candidate Senator Obama won, that no one was allowed in the convention without proper identification. And I because that was so strict at these prior Democratic National Conventions requiring photo ID, proper identification, Ms. Whitaker, in your research, have you found any lawsuits against the Democratic National Convention for requiring such stringent voting ID requirements and photo ID requirements to get in to be able to vote at the convention?
Thank you, Congressman. We have not conducted that research, but if you would like us to, we would be pleased to do so.
Yeah, I would love that because I have not been able to find any lawsuits, and it's just interesting why that would not be discriminatory to get into the Democratic National Convention. I know when I tried to get into the Department of Justice when Eric Holder was the AG, incredibly rigorous, and I would have thought as a member of Congress that was all right. But in any event, we talk about discrimination in voting, and it shouldn't be allowed. Whatever needs to be done should be done to prevent any type of discrimination. On the other hand, we also should be just as adamant about preventing dilution of the vote. I heard mention, gee, we ought to give everybody a chance to vote. Just let everybody vote. Well, that is a huge dilution of the people that are United States citizens, who are the people that are supposed to be able to vote. And at some point, unless we totally lose the group mind of this country, at some point, some court, hopefully the highest court, will recognize the damage that's done when votes are diluted by people that are not allowed to vote, that vote more than once, that get on buses and go to different areas, and that we're in college towns. College students are told, use your college ID to get to vote here, and then you don't use your driver's license. That way you can use your driver's license back where you live when you're not in college. Those are forms of dilution of the vote, and I'm hoping that what solution we come to will deal with all types of vote dilution and discrimination, so that the vote will come back to mean what it should mean, being one person, one vote, and being one person should be allowed to vote, but let's make sure there's not more than one person voting on the same.
Thank you, Mr. Gohmert.
Thank you. I yield back.
I think we've come to the conclusion of our hearing. I do want to recognize once more second Ms. Johnny Turner, and I think it's particular. There are many deltas here, but Ms. Turner was the head of the NAACP in Memphis for years. She was a state representative. Her husband was a state representative, and she has a long history of fighting for voting rights and civil rights. And it's appropriate that you're here today, and you should be recognized for your work and your husband's work. Thank you. And that concludes our hearing. All members will have 5 days to submit questions. I thank all of our witnesses for appearing today. 5 legislative days to submit additional questions for witnesses. The hearing is adjourned.